can we help you do that? I just want to go over your total qualifications.
Sure.
What's your education?
I have a master's degree in organizational psychology. I had a double major, so I have bachelor's degrees in both biology and psychology.
Okay. And your first employment was where?
My first employment after graduate school would be with the CIA.
Okay, you were there how long?
From 1983 to 1987.
In 1987, where'd you go?
At that point, I became a special agent with the FBI, first serving at the academy, and after the academy, I was assigned to Los Angeles.
I think everybody here will stipulate as far as like background stuff and as far as his experience, that's not really what we're questioning. We're questioning how he applied it to the facts of this case.
I do have one thought on that matter that I haven't shared yet.
Oh, okay, sorry.
It only came to me just now, if I may briefly.
Please.
We were not made aware that Mr. Joyner had any experience as a patrol officer or a peace officer in the state. It wasn't disclosed to the CD. Given that we're litigating a case involving peace officers in Texas and how they acted in this particular case, that would have been invaluable information to have for us to investigate and interrogate his qualifications as an expert in this particular area. It would have allowed us to get records from Spring Valley Village as to his employment, what his actual experience is, whether he's had any disciplinary issues there. We've been kind of deprived and caught by surprise now with this witness. There's really critical information that wasn't disclosed to us. We got an outdated, incomplete CV, and so this feels a little bit like ambush. So we've come into this trial expecting I'll give it to him, experienced in federal law enforcement, but we had no notice that he had any experience in state law enforcement, which, as Mr. Lunan and Mr. Harrison pointed out, is the focus of this case. It's state law enforcement and their standards.
And, Your Honor, that's particularly important in this case after the people who were sponsoring him told the court that he was wrong and that they were not going to be calling him as a witness.
May I ask a few questions about? Sure. Mr. Joyner, is the CV that may have your state law enforcement experience, is it available on the internet?
I don't believe so. I believe on my website it has one of the older CVs and not the current CV. I can check right now if you'd like.
Please. And, Your Honor, while Mr. Joyner is looking up for the status of his current CV, I would also note what has been disclosed to defense. Page 6 of that enclosure, he's listed he's currently a licensed master peace officer in Texas, that he has been a frequent contributor to the Texas Commission on Law Enforcement, TCLO, that he is a member of the Texas Police Association, and in his previous testimony has testified in state courts on use of force against 4 officers charged and against officers so charged in several states in this district, this county, Travis County, Harris County. So there is a basis to determine he's well versed in the application of state law.
And to be clear, Your Honor, my concern is less a matter of qualification, it's a matter of fairness and adequate disclosure of information that we're entitled to under 3914. The very fact that he's a peace officer who ostensibly has TCOL training goes to the very heart of this case. That's information that's in the sole possession of the state. We can't just go get it. It should have been turned over to us as part of the basis for this expert's opinion, and we received no notice in that regard.
You guys able to provide that to them?
It's information that we didn't have, Your Honor. Yes, we had commissioned him for a report. I don't have it. The CV that I have is posted as what was provided to the defense.
I mean, he's testified about law enforcement matters. He obviously worked as a law enforcement officer, but he hasn't provided that information to you?
The fact that he had state law enforcement officer did not come in the initial product, the initial CV. I did not make a subsequent inquiry from him of that. I don't believe it's any intent to deceive anyone. Simply an outdated CV came forward with the product.
So Your Honor, let me throw this in here. We received an expert report, and this goes to the failure to properly disclose information. We're hearing today that he looked at certain videos for the first time. In the first expert report, he said he looked at Salinas, Alejandro, Villalobos, and Flores body-worn camera videos, and he referenced that in the table of contents and in his report. Then, after we had the kerfuffle about they're not going to rely upon him anymore, Mr. Harris sent us an email about a subsequent conversation with this witness, and it was a disclosure under 3914, and this we asked for an addendum to the initial report. I asked for that by email because of the 3914 disclosure, and this witness wrote a report, and he said that he looked at additional videos of Officer Rojas and Officer Ramos. So what we have here is that this witness is now telling this court under oath that he looked at an additional video that's not disclosed in his expert reports. So there's been a failure to disclose information, and we asked what notes existed for Travis Thompson, and he said he had none. And if we take him at his word that he did in fact look at Travis Thompson's video, he failed to disclose that, and the state failed to disclose that in the addendum that we had asked for in the middle of this trial. So, you know, we asked for witness disclosures and expert reports and expert information prior to the beginning of this trial, and we're giving information in the middle of trial while it's ongoing that they failed to give us at the beginning, which we were entitled to under 3914, under the due process and under the Michael Morton Act. So to permit this witness to testify now would be a manifest injustice, and we ask that he be stricken.
And just one point of clarification to kind of piggyback on what Mr. Cifuentes said. I'm not, as to the T-Cole information, I'm not suggesting that the prosecutors have it and didn't give it to us. However, they are constructively in possession of any information that the government has. T-Cole is a state agency. They would have an obligation under Michael Morton to get that information, whether or not Mr. Joyner volunteered it. The onus, as we all know, having done the job, is to go and procure that information. So if they know, or should know, that he was a state peace officer, that's basic information that either they should have gotten on their own or at least disclosed to us that he was a Texas peace officer so that we can make an appropriate request under 3914. We've been deprived of that ability. We're now in the middle of trial. We don't know what impact that would have had on experts we might have called, on how we might have examined our experts in this trial. We've been deprived of that opportunity, and so I endorse Mr. Cifuentes' request that Mr. Joyner not be allowed to testify.
So State, did y'all not think about getting that information, or what's the thought process?
Your Honor, Mr. Harris may have some thoughts. First of all, we went on through this in some of the discovery hearings you might remember before trial. The state has no obligation to turn over things that are not written. Okay, there has to be documents, and there are no documents that he's given us that says I watched some other video or Travis Thompson's video, and he doesn't have an obligation to write down that he watched a video. So that's not discoverable under Michael Morton. It includes documents unless it's exculpatory, and it's not. It's not exculpatory. Unless it's mitigating, it's not mitigating. So this kind of demands that the defense repeatedly make that the state knew something and didn't turn it over isn't required under our discovery rules and our statutory rules with that.
It's Brady, right? I mean, potential Brady, right?
Well, what they've been given, with the report that they've been given, Your Honor, it says, I am currently a licensed master peace officer in Texas. They know that. They have the ability to send out a subpoena and investigate that and get those records themselves. We don't have, we don't have his birth certificate. I don't know if he was born in Texas. We don't have his school records. If he went to attend school, and just because it went to a government, because he's affiliated with a government,
We're talking
full
about potential
obligation
Brady,
on the state.
right? We're not talking about birth certificates or school. We're talking about potential Brady, anything potentially that could have any sort of Brady material, right? You would be,
where he was employed?
yes, you would be obligated to get that, wouldn't you?
If we had it.
If it exists.
Not if it exists, if we have it. If we have it. It doesn't say if it exists. It says if the state is in possession of those
I
items.
disagree with you. I think it is required. It is required to get that information to see if there's Brady for the defense to look at.
Okay, if we have reason to believe there's a report or somewhere that provides that information, then we have an obligation to get it. If we don't have any reason to believe that there's Brady material, we can't be obligated to possess it and turn it over.
And Judge, I think
It's just not the law.
I think, with all due respect, I think Mr. Linden is thinking of the old way of doing things. The responsibility is on them to look. So I think that the court is on the right track. It's their responsibility to look. He got close to saying it's their responsibility to do it, and it's not ours. We've all done that job. Mr. Linden's been doing it for 37 years. The rules have changed, and the current status, the court is in the right arena, for sure. You know that, Judge. Is that the responsibility is on them to check. Not if they think. If they think, because what they think is different than what we think, or we would be having this trial. Because I think they're wrong, and they think we're wrong, and so we're having a trial. So with all due respect, it's irrelevant what he thinks. It's what the law requires. And it requires for him to look to make sure, and then to turn it over and disclose it. Because it could be potential Brady. We're not saying it is or isn't right now, Judge, but that's not the standard.
And Your Honor, this particular case and instance even begs for more disclosure, because frankly, I've never seen in the entirety of my career the state, and they weren't even going to tell us until they were pushed, when they go on the record and say, oh, our designated expert, he's wrong. We disagree with him. That is certainly Brady. It goes to impeachment, it goes to Brady, it goes to mitigation. And so, because of that, certainly we'd be entitled, I want to know what his training hours were via T-close, and find out what is, we didn't know. I think 16 hours is usually what reserve officers have to accrue to be a reserve officer. It all goes to his qualifications and...
All right, State, so you're making the argument that Heath does not apply in this particular situation? Is that what you're saying?
No, if there was, he says if we got evidence, we got it late. If we got it late and we turned it over late, and we should have gotten it sooner, or we had it sooner and didn't turn it over, then the court would be able to exclude that evidence at trial. That's what Heath says. That's all that he says. So in that case, it was a 911 call or something of that nature. The state turned over to the defense a day or a weekend before the trial, and the state had the opportunity to get it because it was the PD had it the entire time. They're the PD that filed the case with them. And I don't disagree with Heath. Heath is fine. We have an obligation, what we have, to get it to the defense. It's something that we have. Not something we don't have. Not something that's in another agency, in another county, in another state, whatever these kinds of things. Now, if we have reason to believe, because the witnesses told us, he was disciplined as a police officer in Iowa, okay? Then we'd have an obligation of going to get it and ferret that out. But we are under no obligation to look up and do a background check on every witness we have to see if they've done anything wrong. We do not.
Your Honor, I'd like to read into the record an email exchange that's very important. It was on October 19th, and it was late Sunday in the evening, close to 5 o'clock. We received an email from Darrell Harris that said ADA's David Noonan and Darrell Harris had a telephone conversation with state's expert Chuck Joyner, Sunday, October 19th, 2025 at 2:05 p.m. To prepare for this call, he was provided body-worn camera footage for officers Jesus Rojas and Robert Ramos that he had not previously reviewed. We discussed his review of the additional videos and whether that changed his previous opinion. In that discussion, he told us the following, and he listed 3 things. to which I responded shortly thereafter, and I conferred with all of the team before sending this email. And they can recall that I sent this email to Mr. Harris and Mr. Luna. Since this report seems to be a material change in the expert report previously provided, I trust you will provide a supplemental report from Mr. Joyner documenting his revised opinions. This supplement should be provided as part of the state's ongoing duty to comply with our previous discovery request, and the state having filed a discovery acknowledging, representing that it had provided everything to the defense. Since the state has made an affirmative representation that everything has been turned over, the state would be required to provide a supplemental report from Mr. Joyner instead of a synopsis of your notes. The only reason the state would not provide a supplemental report from Joyner would be if the state affirmatively represents that it has abandoned any attempt to use Joyner as a witness at any stage of this trial. When shall we have the supplemental report, or has the state abandoned Mr. Joyner as an expert? They provided us the report reaffirming that the only new videos were of Ramos and Rojas. If that's the case, then either this witness has misrepresented on the witness stand that he reviewed Travis Thompson, or the state has failed to disclose that Travis Thompson was reviewed, and this witness should have updated his supplemental report regardless of whether his failure to include it in the October 20th report was just a clerical error. So since they failed to update the report about Travis Thompson and what they reviewed in Travis Thompson, he should be excluded from testifying.
Mr. Norton was trying to say something earlier.
Judge, actually, just one small thing, because I'm going to let Mr. Newman, but the one hand they say, we should have known because he says in the report they gave us, he's a master peace officer in Texas or holds a certification. Goose and Gander, they should have known. We didn't, it never says anywhere about being employed as a reserve, where, I don't even know where Spring Valley is, I think it's in Harris County, but I mean, who am I going to give, I mean, it just doesn't make sense that they're shifting it to us and act like they had no obligation at all, and they do.
And I think, Your Honor, that he speaks specifically to this very circumstance.
Yeah, because it seems like the argument that Mr. Lunan was making was not an accurate rendition of what Heath holds. Am I right about that?
Just the very first paragraph of Heath, the Court of Criminal Appeals states, the question they pose is, does the mandate in Article 3914, the Michael Morton Act of the Texas Code of Criminal Procedure, that the, quote, the state produce discovery, quote, as soon as practicable after receiving a timely request, include discoverable items which, unbeknownst to the prosecuting attorney, are in the possession of law enforcement agencies. The Court of Criminal Appeals says, yes, in this context, the state means the state of Texas and includes prosecutors and law enforcement. As soon as practicable, as the phrase appears in 3914, A, means as soon as reasonably possible and does not contain a knowledge requirement on behalf of the prosecution. I'm not accusing Mr. Luna and Mr. Harris of knowing the information and failing to turn it over, but Heath makes clear that they have an obligation, unlike just a generic background check on a civilian witness, when they have a witness, particularly an expert, who was a member of law enforcement of this state, Heath makes clear they have an affirmative duty to seek out that information.
And as much as I'm salivating to cross-examine Mr. Joyner, Judge, I think it's obvious that it's your discretion to exclude him from this jury hearing from him.
I don't know if it's so much a discretion. It seems mandatory at this point.
Fair enough.
So I'm going to sustain the defense objection. Anything else? All right, thank you, sir.